Gold Beach, nature's wild side. It's a whole new experience with Gold Beach Rocks. You can create your own memory or create a treasure for someone else to find. Gold Beach Rocks art kits are available at local merchants. Don't forget to hashtag Gold Beach Rocks. Find out more at goldbeachrocks.com.
It's Thursday, July 25th, 2019, Plan Commission meeting, and we'll start with the Pledge of Allegiance. Pledge allegiance
to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Is there anybody in the public or in the audience who has any comments or items to bring up that is not on the agenda? Okay, then we'll,
Can you list what items are on the agenda?
yes. The AD 1907 Adams conditional use, AD 1909 Kiewit Foster conditional use. Those are things of interest primarily.
Okay. Good. So if they want to talk about anything other than that, they can. Okay, thank you.
Any comments or changes to the agenda? Okay, review procedures for the quasi-judicial
That's
hearing.
me, I'll do it.
Yeah, I'll do it. Recording. Oh, thank you. I forgot roll call.
Oh.
Commissioner Freeman,
Here.
Commissioner St. Marie,
Here.
Commissioner Jensen,
Here.
Commissioner DeWald,
Here.
Commissioner Lang.
Here. Thank you. Okay, now take it away.
Now it's my turn. I will now describe the rules that govern these proceedings. First, staff will give a report. The staff report will describe the criteria that an applicant must satisfy to receive approval. The board may ask questions of staff. Then the chair will open the hearing to the public. Although tonight we are not having a hearing, the public record the hearing record has been closed at the last meeting for these two applications. The applicant will be allowed to speak first if it was a hearing and may ask for rebuttal time. After the applicant presents, any person may address the Planning Commission. Any testimony, argument, or evidence you give must relate to the criteria listed in the staff report or Curry County zoning ordinance or Curry County comprehensive plan or state or federal constitution, statutes, rules, regulations, or planning goals that apply to an application. Before the hearing is closed, and again, the hearing is closed tonight, any participant may ask for an opportunity to present additional evidence, argument, or testimony regarding an application. If you ask for more time, the commission will either continue the public hearing to a certain date or close the hearing, which has happened, and leave the record open for additional written evidence, argument, or testimony. If the hearing is continued, persons may present and rebut new evidence, arguments, or testimony. If new written evidence is submitted at the continued hearing, any person may request prior to the conclusion of the continued hearing that the record be left open for at least 7 days to submit additional written evidence, arguments, or testimony for the purpose of responding to the new written evidence. If the hearing is closed, and tonight the hearing is closed, but the commission leaves the record open for additional written evidence, arguments, or testimony, the record shall be left open for at least 7 days. Any participant may file a written request with the Planning Commission for an opportunity to respond to new evidence submitted during the period the record was left open. Unless waived by the applicant shall have at least 7 days after the record is closed to all other parties to submit final written arguments in support of the application. The applicant's final submittal shall be considered part of the record but shall not include new evidence. Failure to raise an issue with specificity before the close of the record so the commission and any party can respond will prevent you from raising that issue on appeal. Failure to raise a constitutional issue with specificity will prevent you from bringing a court action for damages. I'm completed with my statement.
Okay, is there anybody has ex parte contacts, bias, or conflict of interest on either of these?
I actually have a form if anybody declared a conflict of interest for the last meeting. They're welcome to fill out the form and sign it, so it's an official form in the record of the proceedings on these applications.
Do you want this before we leave tonight?
Well, I think only one person was going to declare a conflict of interest. Yeah.
Is anybody in conflicts? Okay, I have it's not really a conflict of ex parte on the Kiewit issue. I was in the rock business once upon a time. I'm no longer in that business. My family was in it, and they are not either. I have no financial thing to gain from this conditional use for Kiewit, and nor does my family, so I don't feel it would cause my judgment on making a decision.
I have a question. Will you be able to make your decision based on the facts and evidence and the standards in the code, facts and evidence in the application of materials?
Yes, sir, I will.
Thank you.
Thank you. Thank you. Okay. Then we'll move on to agenda items. Approval of the June 20th, 2019 meeting. Any corrections or additions or modifications? Then I would entertain a motion for approval.
So moved. Second.
Move to second. Roll call, please.
I'm sorry.
For the minutes.
Okay. Commissioner Freeman,
Yes.
Commissioner St. Marie,
Yes.
Commissioner Jensen,
Yes.
Commissioner DeWalt,
Yes.
Commissioner Lang.
Yes.
Thank you. Okay, moving on to discussion decision on AD 1907 Adams conditional use for Pistol River gravel extraction. I have ex parte, so I will not, Diane will take over for me.
I'm gonna need a little guidance through this, because it's come up again.
We're ready, we're
Okay.
ready. I'll give the staff report, a brief staff report. This application, it's application AD 1907. It was submitted by Ronald Adams, who's the owner of the property. It's a request for conditional use approval by the Planning Commission for the mining and processing of aggregate on the Pistol River. It's in the forestry grazing zone. His request was an estimated 10,000 cubic yards of gravel taken off some area on his property. At the hearing, he did not specify where and how that gravel would be extracted. And the application you guys reviewed last time, essentially what occurred at the last meeting is there was a public hearing. The Planning Commission closed the public hearing at the end of the hearing, at the end of the meeting last time, and made a decision to leave the record open for 14 days for people to submit additional comments that in regards to his application. That also gave the applicant the opportunity, after people submitted their comments, to respond to the comments that were submitted, and he had 7 days to do that, and he did present additional comments. Essentially, what happened was when the applicant looked at the comments that were submitted by the public, the applicant made a decision to submit some responses to those comments to try to clarify his proposed application. In the process of submitting those additional comments, he put new information into the record. And according to Oregon Revised Statute, the conduct of local quasi-judicial land use hearings, notice requirements, hearing procedures, because there was new information presented by the applicant, there's the question for the Planning Commission to reopen the record to allow people that are interested in or commenting on that new information to respond to that new information submitted by the applicant. Legal counsel is here tonight to make sure that we proceed with the proper process. You guys did receive a memo in the record as an attachment to the staff report from the Assistant County Counsel, Shayla Kudlak, and she's made a suggested motion to the Planning Commission based on the request from people to continue to open the record or have the record open again. She's suggesting that that might be an appropriate thing for the Planning Commission to do. There have been some questions by members of the Planning Commission on what was the new information submitted by the applicant. In the case of AB 1907, Mr. Adams specified his method of operation, which was to essentially take gravel off the gravel bar by scalping the bar, and that was new information that wasn't presented at the hearing or within the application. So with that, I'll let you guys deliberate or ask more questions of legal counsel.
Who's chair? Can I just offer something? So, bottom line is, we're not, the commission is not in a position to decide whether to grant the application to remove gravel. The statutes, and you heard the planning director give that procedural explanation at the beginning, and we're in the section of that procedure where the record, the hearing is closed, the record was left open, and to present new and additional information, scalping has come in. So now, because of the new information, the law says that persons can now comment on that new information. And the question then for the Planning Commission is, it says you have to reopen the record, and then the question will be, how long do you want to reopen the record? I think in one case we had a request for 7 days, in another case we had a request for 14, but really it's up to the Planning Commission to decide how much time they're going to give to grant, to leave the record open for responses only to the new information. So what we're in is a kind of a narrowing down process of issues. It's a kind of an issue narrowing. We started out with a lot of issues, we got some new information, now the questions should only relate to the new information.
Counsel, can I ask a question of you?
Sure, of course.
Is it unusual just to open it to the next planned Planning Commission meeting, which would be the following month of when we hear the other? Or is this something that is typically,
Couple of things. So as far as when you will consider this again, that's a slightly different for how much time you're going to give people to respond. What my suggestion is if your desire is to deliberate and make a decision on all the information, it would be to give enough time for people to comment on this new information. And technically, if you, let's say for instance, I'll just use for instance, if you gave the public 7 additional days to comment now on this new information from the applicant, the scalping procedure, et cetera, and I know we're using shorthand, if I'm not mistaken, the actual document is posted on our website. So
That's
if
correct.
anyone wants to actually know what the new information was, it's actually on the website. So then the question is, they would have that you would set the time for anyone to make comments on the new information. And then after that time, the law says the applicant gets at least 7 days to respond. So that's 14 days if you go 7 and 7. And then the general idea after that is staff will synthesize from the very beginning all the way through to now, to the end of that time, and present a staff report to you. And I think your question would be of staff, if we did 7 days and the applicant had 7 days, would you have time to synthesize this and bring it back to us at the next
That's
meeting?
exactly
So-
right.
So that's a question, I think, for the director, but yes, if you wanted to, if your goal was to decide this at the next meeting, then I think making a motion to leave the record open for an additional 7 days to respond to new evidence, then by law, the applicant would get 7 days to respond to that. So, and also the applicant could respond within that time if there was questions that they wanted to answer, if new questions came up. So then it flips back to Becky Crockett and her staff if they could assimilate all of this before your next meeting, given those timeframes.
Yeah, if you leave the record open or open it again for 7 days, that essentially will give me about 4 work days to turn it back around and give you a staff report.
And the only questions that we can ask tonight of either staff or council is pertaining to executing the process. Has nothing to do with asking questions, I guess, about, or we're not going to hear any comments about the file or the case.
Thank you. If I could, there were some questions presented to me by email, and they involved, what about these conditions that an agency will approve this later? What if, there were some hypotheticals. What if we find that they haven't complied with the conditions? How do we enforce this? Those kind of things. My response to that email was really the timing of answering those questions is prior to your deliberations. Those questions go to more or less the ultimate decision. And right now we're just into how much time are we going to leave the record open for people to respond to this new evidence. Once everything comes in, the director will create a comprehensive staff report. I will review the file for legal issues, including those kind of questions, write out a memorandum. That'll be a supplement similar to the memorandum you have here. That'll be made public. And then at that meeting where you actually decide things, you'll have every opportunity to ask staff, and including council, all of the questions you have on all those points. So that's I think kind of a nutshell. I don't think we'd be making the best spending of our time to just answer a few questions now and probably go over it all again later. Did that answer your question?
Absolutely,
Okay, thank you.
absolutely. So I'm going to present to my fellow commissioners, Madam Co-Chair, I move that we reopen for 7 more days of public comments regarding the new findings, evidence, whatever you want to call it.
Evidence, yep.
And then an additional 7 days for then for Mr. Adams to reply to that.
I second that.
Okay. So that was Commissioner Jensen,
Aye.
Commissioner Lang,
Yes.
Commissioner DeWalt,
Yes.
Commissioner St. Marie.
Yes.
Are you out of this other one too?
So if I could, if people were here about the Pistol River application, for lack of a better word, there was new information submitted, it's on the county's website, and if you want to comment on the new information, you have 7 days to submit additional comments to the planning director.
7 working or 7 calendar?
Thank you, I believe it's calendar, that's a good question, if anyone wanted to know, but it just mentions calendar days.
Thank you.
Yeah, and the website, to get to the website, you just have to type in, if you're a Google user, just type in Curry County Planning Commission. That's where it's at. It's not under Planning Department, it's Planning Commission, because it's the Planning Commission that's responsible for making a decision.
Do you have a phone number people could call in case they get stuck at all?
What's your phone number, Nancy?
would be 541-247-3284.
But the comments do have to be in writing, so just telling her, it's just to help you navigate and get to the website. So unless there's any questions, I really don't think we're going to be discussing the Pistol River application anymore.
Next item on the agenda is just
Just means more cookies for us.
Okay.
I was wondering why this said adjourned at 7.
Now you know.
Front row's open.
Okay. Next item on the agenda, discussion decision on AD 1909, Kiewit Foster conditional use for upland quarry. Becky, you want to give a quick?
Absolutely. This is application AD 1909, a request made by the owner, Andrew and Diane Foster, and the applicant is Chuck Nyland from Kiewit Infrastructure. The application is for upland rock quarry on a timber zone. At your last meeting, this is very similar to the Adams application. At your meeting, you closed the public hearing. And you left 7 days open for the record. The applicant had the.
Did they leave 14 days on this one?
7.
7, 14 on the first.
Yeah, this is 7.
Thank you.
Okay.
All right.
14 on Adams.
Thank you. I got them mixed up in my mind. I apologize, Director. Planning Commission.
Thanks. Okay, so essentially this is very similar to the Adams application in regards to what occurred. Essentially, there were comments received into the record within that 7 days. The applicant looked at those comments and then, in this case, submitted quite a bit of new information. They submitted a substantial response to all of the comments that were received. As a result of that, that was new information that was presented into the record by the applicant, which triggers the same issue that we had on the Adams application. That is, in accordance with the ORSs, we have a requirement, the Planning Commission has a requirement to open the record back up. So the question is, how many days do you want to open that record back up for people to review that information that was submitted and respond to it?
Question,
Yes.
and our choices are 7 days or 14 days?
Your choices are, those are two choices,
Oh,
yes.
so we have
You-
multiple
It's a
choices.
minimum of 7.
No less than 7.
Yeah.
No less than 7.
If I'm not mistaken, did one of the public comments, sorry, John Huddle again, did one of the public commenters ask for 7 and another public commenter asked for 14, or?
That's my recollection.
Okay, so when you ask if those are your only two choices, those are the only two times that have been requested, so.
Proposed, yeah.
But we don't have to make a decision based on those requests. We can extend that or make it shorter.
Well, you have
No,
to
but
go
can't
in
make it shorter.
at least 7 days.
At least
have
7,
7,
okay,
yeah.
okay.
I think you could extend it, but I think you would have to, if someone was making that motion, they'd have to give,
A
you know,
good reason.
reasons why they would extend it beyond any request.
Understand?
Yep.
Fair enough.
I think this puts you in the same time frame as with the Adams application, correct? 4 days
Yes,
to pull it
yes.
together?
4 days to take all of the information that's been presented into the record, everything that you have, and make some kind of conclusion about that and a recommendation back to you in a staff report, and we would publish that, or excuse me, post it online on the website so everybody can read it and be prepared at the August 15th Planning Commission date to have that discussion.
Could I ask a question?
Yes.
Are you saying then, Director Crockett, that prior to the August 15th meeting, the Planning Commission would only have 4 days to review your final
No,
staff
I
report?
would have 4 days to write the staff
The
report.
report.
And to
Oh,
send
prior
out-
to, and they would have it at least how long, or
At
the
least,
public would have it?
Well, my goal is always 10 days.
Okay.
And that, that would
Thank you.
get it to 10 days.
Is that, I was wondering if you were saying you
Yeah.
only have your report out 4 days before the meeting, but your goal is to have it 10 days, and therefore, after those timelines, you would only have, you're giving yourself 4
I'd
days.
I'd have 4 days,
Okay.
yeah. And the reality is, everybody that's been involved in these projects, you know, for and against, wants to be able to read the information.
Mhm.
And so, you know. we
Trying to
want
give them as much time.
as much time as possible, and to give you as much time as possible.
Mhm.
Okay, are you prepared, Michael?
Am I prepared?
Then it's the same.
You want me to make the motion?
If you would, please.
Okay. I motion that we reopen file AD 1909 Kiewit Foster for 7 days, no more than 7 days for additional public comment, and then another 7 days for applicant response.
I'll say.
Moved and seconded. Roll call, please.
Commissioner Johnson,
Yes.
Commissioner Lang,
Yes.
Commissioner DeWald,
Yes.
Commissioner St. Marie,
Yes.
Commissioner Freeman.
Yes. Okay. Sorry about everybody having trouble so far.
There.
Planning director updates.
Okay.
I'm sorry, give me just a second. Yes?
I had one question, perhaps for county council, or observation. At the last meeting, I mentioned my concern about noticing, and how we notice. And so my question is, and so I'm needing to be educated. You know, well, that's the first part of it, is where it gets noticed in two papers, is that correct? And then the
That's
website,
correct.
the website, of course.
Well, and so when we receive an application, after it's deemed to be a complete application, we do notification in accordance with what the code requires. The code requires a 500-foot notification to all property owners surrounding the property where an application is being proposed. So, and that gives the surrounding property owners the information about, is it administrative review, is it going to the planning commission, etc. So everybody surrounding the property gets notification. In addition to that, if there's a
Question before you go on that. So practically speaking, when you say 500 feet, is that like a placard, or is that just the people who live within 500 feet and then they get a letter or a phone call, or how does that work in practice?
They actually get, the property owner
Gets
gets
a piece of paper.
an actual legal
If
notification.
they're 500 feet from the project?
Yes,
No, from the property line.
the property line.
The property,
this.
Yes.
Okay, all right, great.
And you know, whatever you do, you're never gonna get everybody for some reason. It just doesn't work.
No, no,
Forever
no.
and ever. I mean, no matter, you're gonna have to draw the line somewhere.
No, I'm just trying to be,
I
I'm trying to get
understand.
educated, yeah.
It's a sad deal that some people don't get notified, and they should be.
Yeah.
but-
And so, I'm not done. And so then, so that's one way people get notified. And then the other is that it gets, at least in terms of the meetings and what's gonna be on the agenda, is in the papers.
That's correct.
And that's which papers?
That would be the pilot, and what's the
The-
Gold Beach paper?
The reporter.
Are there other papers that we could put it in?
In the Port Arthur paper.
Is it go in Port Arthur paper?
I don't think so.
I don't think it does. That would be a request. It just seems that would, unless there's a legal reason why we cannot.
Well, those are the two papers that the county recognizes as the legal arm of publication for notices for planning commission hearing.
Is there a case to be made for North County having access to the printed material? There's no?
I don't know what you mean.
Notifications for.
Oh.
Is there a problem? Well, let me ask
Well,
it differently. Is there a problem putting it in the Port Arthur paper?
So there's no prohibition on giving more notice than is required in our code or in the state statutes. And the statutes, I think, only require notice of people living within 200 feet, and we've gone beyond that. And I just wanted to say, at the most recent Board of Commissioners meeting, they actually, I think, added so the Port Orford paper to our listed papers.
Okay.
I think that would be helpful. Okay.
Got it?
Also,
Thank you.
if I could, I have another question for the director. My understanding is besides those two ways of notification, isn't there an opportunity for people to affirmatively reach out to you and say, I would like notices of decisions to be emailed to me, or notice is, do we have that happening as well? Are you aware of that, or is that only for a decision, not for a hearing?
Absolutely. Sharon was still asking questions, so
Okay,
I
thank
didn't
you.
complete our description of what notifications are. Yes, we have an active list, and if you want to be on the active list and receive notifications for all of the planning actions, you're welcome to put your name on that list. And we do send people notification. A lot of those people that are on the list have given us their emails, so they receive that notification electronically, which helps with the paper situation. So that option's available. The other thing is, and what we've really tried to do with Nancy and with Penny, is to put all of the information on the Planning Commission website. And, we're trying to transition to put all the administrative decisions on the website too, not on the Planning Commission website, but to have that available electronically so people know where to go to keep informed. Go ahead.
After you're done, I just want to,
Yeah. It was just real interesting, all of the planning directors in the state of Oregon, just this week, had a poll asking what counties post all their stuff on the website, including the decision, and it's pretty mixed. We're not the only county that doesn't have a lot of staff. So, you go from, Portland area counties where everything gets posted on the website to, Lake County and here where they don't post hardly anything at all. So it's really, a question of we'll do the best we can. If somebody really wants to be notified of all of the decisions, we're going to do our best to give them that information. When I get a phone call about an active land use application, those are my priority calls because I know those people are real anxious to get that information and know what's going on. So we really try to do the best we can.
the only other, you asked if there was a reason why we couldn't put a notice in more newspapers or whatnot. The only wrinkle there would be, we shouldn't just pick and choose what newspapers we put we should be uniform in our
Fair.
application of the notice, so,
Okay, yeah.
so that everyone is being treated equally, and
Fair
so currently that would be why we wouldn't say, oh, well, we need to do this kind of notice here and this kind of notice there. So if we're gonna do a notice, it should be the same on all our applications, is my
That's
recommendation.
good, yeah, that sounds right.
Thank you.
Thank you very much.
Planning director updates?
Okay, the updates I have is, first of all, I gave you some copies of some interesting articles that pertain to your decision-making. One of them is out of the Capital Press. There is an article about the Adams application. This reporter for the Capital Press did call me and asked me for the information. We sent him the entire file on the Adams project, and I actually was really pleased with the article. I thought that he did a really good job of describing what was going on, so that was good. This came out yesterday. This is an article that pertains to the application that you have right in front of you. In part, I was a little surprised it came out so soon, but it did, and I wanted to just let you know, in this article, it says that this subdivision north of Gold Beach has been approved. Okay, what happened is, and it's all in front of your seat right there, essentially, they submitted a PUD, which I can approve administratively, and I did. And then they turned around and submitted a subdivision application, and that's what you will review, because I don't have the decision-making authority to review and approve a subdivision. The Planning Commission does. So this is one that popped into the paper, and I just wanted to give you a heads up because it is probably going to be on your agenda for August 15th with the Adams application and the Kiewit.
So we're bringing dinner to that meeting.
It's, and I have another possible one coming up, and right.
Sleeping bags, we're
Right-
bringing sleeping
Right
bags.
behind that, we'll have the Sika Beach RV Park, which was with an application that was withdrawn probably about 8 months ago, and then it's being resubmitted in a much different form. So you have a heavy agenda the next couple of months, you really do.
Council brings up a good point. Can we get a coffee maker in here? Is it possible? Do you provide
We actually
that?
have a coffee maker in the other room. We provided water this
Yeah,
evening.
I don't think coffee's a good idea, because then you have the excuse to go to the bathroom.
Yeah, that's true.
We're gonna have to take
If you need
breaks
a-
anyway.
If you need a cup of coffee, we can get you a cup of coffee.
I have a question, Becky. Is it typical for PUDs to then go to the subdivision application process? Is that, why did they apply and get the PUD approved? And why would they go to the subdivision then? Because
Because
planned
once-
urban development is very similar to a
The
subdivision.
planned unit development allows you to do, lots of things within
Right.
a development. And a lot of times, the lots aren't sold, they're held within that PUD management system.
Okay.
If you want to sell the lots, you actually have to do a subdivision to cut the lots into dividable pieces for purposes of somebody buying the lot
There we
and
go.
the house to be built. We talked with the applicant at length about that. When they started, they weren't really sure they were going to sell the lots, and then they transitioned into absolutely they want to sell the lots. So then that's the subdivision.
And then if a commission member was to disclose any potential ex parte, is that done now or when that meeting happens?
When the meeting happens,
Yeah.
it's probably be on the record of that meeting.
Okay, all right.
And technically, there have been some cases that say reading a newspaper article about an application can constitute an ex parte. So Director Crockett, you might just include those newspaper applications in the staff report or refer to them so that they become in the record. And what ex parte means is really outside of the record of the public hearing. And the rule on that is they're not illegal, you just have to explain the contents of the ex parte communication on the record so that if anyone wants to talk about that, they can. So again, we recommend against ex parte communications, but they're not illegal, they just add a couple more hoops and hurdles you have to jump through.
Those are the updates that I have, just to give you a heads up that you have a lot of work ahead of you, and I'm excited. You guys are a good group of folks, you really are. John?
We have 5 members on the planning commission currently. How many openings on the planning commission do we have, and what are the geographical areas of those openings, and how are we doing there?
Well, let's see, there's two vacant positions. One is for the Gold Beach area and one is for North County.
Okay.
Those are the 2 positions that are currently open.
Very good, thank you.
Anything else?
Sure.
Okay. Comments from commissioners?
Thank you. I'd just like to take a moment to thank and compliment staff for a job well done. Getting all this to us takes a lot of work, and it's appreciated.
I second that.
And they were very patient with me.
Ann, did you have something?
No, I was writing you a note to that she had a comment.
Oh, just a second. Anybody else have
She
anything?
whispered in my ear.
Is there any active recruitment going on for the 2 vacant positions?
Not that I'm aware of, although Sharon did bring a person to the meeting tonight.
I've been working it.
So when you say active recruitment, we do post the openings on our county website, which I guess would be a passive recruitment. And what I've seen a lot of times is either members of the planning commission would do some recruiting, which I think Sharon's doing, as well as sometimes the board of commissioners does some, arm twisting or what have you. So
That's how I got on the board, was my arm was twisted by the commission.
imagine that.
Well, I invited somebody from the Brookings area tonight, but apparently Brookings quota's filled.
It is right now,
Okay, thank
in a
you.
good way.
I just wanted to put that out there because, again, we have a 7-member board with 5 members right now, so we're looking for a couple.
I have to admit, I've been so happy with the 5-member board here. I was actively recruiting, and then we have our 5 board, and I'm happy, so I have
You only,
have
I know,
not.
yeah, 7 people's a lot to manage.
Yes. Well, my biggest fear is to have 6 members.
Yes.
So, yes.
No, you don't want
Yeah,
So we either
That's
need
fair
to jump
enough.
to
Yeah.
7
Fair.
or.
we need an odd number.
Yeah.
And Ted needs to quit leaving the room.
Yes.
Okay.
Okay,
Do we need a motion to adjourn?
would you please?
I make a motion to adjourn the meeting.
Second.
She's been practicing this for a long time.
It's a good thing to practice.
All in favor, say aye.